Legal argument, no vindication in technicality. Why the Vybz Kartel precedent exposes the truth behind Anil Roberts and Rudal Moonilal scandals. Background: the Vybz Kartel case. When the UK Privy Council overturned Vybz Kartel's murder conviction, it didn't declare him an innocent man. Far from it. The court acted because the process had been poisoned. A juror had attempted to bribe another, corrupting the very foundation of justice. The ruling was clear: the trial was unfair, not that Kartel was guiltless. His conviction was quashed not because he didn't do it, but because justice, in that courtroom, had been compromised beyond repair. The grounds on which they have been overturned were due to jury misconduct. It was unsafe to allow the tainted juror to remain on the jury which decided the men's fate. 1. This distinction matters. A procedural collapse is not an acquittal. And in the court of public conscience, that truth cannot be ignored. Application to Anil Roberts and the LifeSport scandal. LifeSport audit and judicial review. Anil Roberts, once the face of the Ministry of Sport, stood in the shadow of the LifeSport scandal, a program marred by revelations of waste, fraud, and criminal infiltration. An audit uncovered a trail of alleged corruption. But when a High Court judge struck down that audit report, it was not because the allegations were false. It was because the people accused weren't given a fair opportunity to respond before the report went public. This was not a vindication. It was a technicality, a procedural flaw. The judge didn't clear anyone's name, only ruled that natural justice was not served in how the audit was released. The judge said their right to natural justice was infringed. The auditors failed to inform the officials before the report was aired publicly and awarded costs. 4. Even then, Attorney General Faris Al-Rawi made it clear. Criminal and civil investigations could still proceed. The allegations were never withdrawn. They remain alive, dangerous, and unresolved. There was nothing in the law of the judgment to block criminal probes. The substance of the allegations are there. They're very actionable and are being acted upon. 4. Legal parallel. Just like Kartel's case, where a conviction was overturned because the process was tainted, not because he was innocent, the court's decision in the LifeSport matter rests solely on how the report was handled, not on what it revealed. The rot may be legalistic, but the stench of scandal remains unmistakable. Application to Rudal Moonilal and the EMBD scandal. EMBD lawsuit and allegations. Rudal Moonilal faces serious accusations, not from political rivals, but from the Estate Management and Business Development Company Limited, EMBD, itself. A multi-million-dollar lawsuit alleges that Moonilal, acting as a shadow director, took secret commissions and violated the public trust. These are not whispers in the dark, they are formal court filings backed by evidence and years of investigation. EMBD's main new allegation is in relation to payments allegedly made by the contractors to third parties connected to Moonilal and the UNC. 5. To date, there is no finding of guilt or innocence. The legal process is still unfolding. Yes, investigations may be slow. Yes, procedures may be delayed. But delay is not exoneration. Silence is not innocence. And justice, even when slow, has a long memory. Legal argument and case extracts. The thread that ties these cases together is simple and damning. A case falling apart on procedural grounds does not mean the person is innocent. Allegations that remain untested or unresolved are not erased by technicality. Justice delayed by due process is not justice denied to the public. The juror was later convicted of attempting to bribe a fellow juror. 1. The auditors failed to inform the officials before the report was aired publicly. 4. Allegedly made by the contractors to third parties connected to Moonilal and the UNC. 5. Conclusion: don't be fooled, innocence isn't declared by a loophole. The public must not be fooled by the smokescreens of procedural victories. Whether it's a bribed juror, an audit quashed on technical grounds, or a lawsuit dragging through the courts, none of these outcomes erase the core allegations. They do not restore public trust. They do not clear names. They only delay judgment. To call these procedural rulings vindications is a betrayal of truth and an insult to every citizen who demands accountability. Let us remember, justice isn't only about process. It's about truth. And truth is still waiting in these cases.
Good afternoon. We are not fearful of any backlash. That's the first thing. Several of our neighbors have the very same legislative provisions which their respective ministers have exercised in some instances, to refuse entry to Trinidadian artists. So there's no backlash because it's a discretion that has to be exercised in this instance, not only in the best interests of the country as a whole, but more particularly, one has to have regard to the interest of children, having regard to our treaty obligations under the Convention on the Rights of the Child, which we've incorporated into our laws, and having regard to the material that is contained in some of the songs. So the protection of the children must be paramount. Well, I don't expect him to say that he's not reformed, but he has his own agenda. I also don't wish to say that I don't believe him, but we have to act on the basis of evidence. Mr. Kartel, before his conviction was overturned, made several attempts to be freed on the basis of ill health, stating that he was close to death's door, and if he was not released, he would die in prison. The moment he was released, he made a miraculous recovery. But one of the things one has to take into account is this, and I am mindful of the fact that he is saying he wants to speak with the youth to have them stay away from a life of crime and so on. But his conviction was not overturned on the merits. It was overturned on the basis of juror misconduct, so that the credibility and reliability of the evidence led against him at trial was not in any way undermined. And the Jamaican Court of Appeal, who decided not to order a retrial, did so on public policy considerations, and their decision in no way affected the creditworthiness or reliability of the evidence led at trial. So it would be wrong, in my view, having regard to my remit, and we've not made a decision just yet. What exists now is a draft order, which is a working document, and we have not met with all of the stakeholders. We still have to meet with the SIU, and there are legal opinions that were sought that would have to be taken in the round before we come to a decision. But what we must not do is give the impression that we are giving legitimacy to someone who only recently was released from death row for murder, and whose conviction was not overturned on the merits.